Mr. Davis, good morning.
Chief Justice, may it please the court. When I received notice of oral argument, I learned that I was limited to 10 minutes, and I said to myself, they're trying to tell you something. And quite frankly, I contemplated submitting on brief, but then I said, I've come this far, I might as well go all the way.
Sometimes it's an indication of nothing other than that there's a single issue,
That's right.
as opposed to if you were here for something like the Arbella case, which had multiple issues.
And this is why I decided to go all the way, because I noted that at the Superior Court level, when I filed a motion to dismiss, it was simply denied. Nobody said anything. I filed the 211-3 petition, and Justice Ireland did the same thing. So I don't know where anybody is coming from. I was beginning to wonder whether I was out in left field all by myself, because I raised an issue about the sufficiency of the evidence. Well, this court will note, of course, that this is the second time that I'm here. The first time was a few years ago when, after the first trial, in which I was not trial counsel, I brought a 211-3 petition because I said that the evidence was, that the mistrial declaration was premature, that it wasn't necessary. And, of course, I got an opinion on that. And so we go back to try the case, and this is my first time trying it, and I found that the evidence at this time was even less than it was at the first time. At the second trial, the evidence was that, well, 10 years ago, the defendant, after going out drinking one night with her friend, parked her car, double parked her car on the corner of Stewart and Tremont Street and went into Dominic's to get a pizza. She left the friend in the car. And at the same time, a group, some company was having a party at the Roxy, which is right up the street. And several people, as they exited the party, were fairly well drunk, including a fellow by the name of Scott Sullivan. Scott Sullivan was so drunk that he got into the defendant's car and tried to start it up. And he would not get out, even though he was asked, and even though even some of his friends, especially Danielle Beauregard, tried to pull him out, but to no avail. Eventually, however, after the defendant returned to her car and they were able to get him out, the evidence shows that the defendant was pinned against the rear of her car by Mr. Sullivan. And the evidence shows that Mr. Sullivan was cut from the phrase you hear all the time, from ear to ear. He almost died. But Scott Sullivan was unable to say who cut him or how it happened. Danielle Beauregard was on the street at the time. She was knocked down, and she did not see what happened. There was a friend with them by the name of Michael Collins who told an altogether different story. He was standing on the sidewalk observing everything, and his testimony was that the person in the car, not the defendant, got out of the car, came around, and that she cut Mr. Sullivan. Well, in any event, the mistake I believe that the defendant made was leaving the scene. She got into her car and drove away rather than wait to see what had happened or wait for the police to arrive. Her car, the description went out on the radio, and it was picked up by a municipal police officer who followed the car and stopped the car and radioed for the Boston police. In the meantime, he observed that the passenger, not the defendant, was trying to hide something. And when the police came, he told them about this. They looked and found that that was a knife on the side of the car of the passenger that was attempted to be hidden.
Mr. Davis, forgive me for interrupting you. Did your client testify?
My client, well, she testified at the first trial. She testified at the first trial, and she testified that when she tried to get him out of the car and couldn't, and when they finally got him out of the car, he held her up against the rear of the car, and he was humping her, and she was pinned, and she had to reach down as best she could into her jeans, and she had a knife in her jeans, and she got it out, and in the process, she slit her jeans. Those jeans were introduced into evidence, and I believe the police officer testified to that effect, Officer Barnacle, that the jeans were split on the side.
And what was the status of that testimony at the second trial? What was the status of that testimony at the second trial?
The Commonwealth, as they often do, and I'm not being critical, they offered her testimony from the first trial.
Okay.
And
so this was in evidence before this jury?
It was in evidence before this jury, yes, by way, secondhand, I call it. They weren't able to attest to the credibility of the defendant by listening to her testify. Rather, they had to attest the credibility of Sergeant Barnacle, who played the role of the defendant.
Correct. Yeah. But in a sufficiency of the evidence case, we have to take that evidence into account, correct?
Unfortunately, yes. But even taking that into account and how much weight you give it, I don't know. But I can tell you this.
Isn't that the jury? Isn't that what should go to the jury?
Yeah, but the jury couldn't agree on anything on this. This is the second time the jury couldn't agree here. Now, I understand that you, at least in baseball, you got 3 strikes, but I don't want to go for a third one. I'm trying to, I want the umpire to call the Commonwealth out now. Let's not do this a third time. But here is the evidence that the Commonwealth put forward. First of all, nobody identified the defendant as having committed the crime. Nobody. The crime was committed by the defendant according to her testimony at the first trial when she said, I was acting in self-defense. As a matter of fact, she said a couple of times, can a person defend themselves? This is the evidence on which they want you to believe that she deliberately cut this man with the intent to kill him. No one presented any evidence to dispute or that a jury could find beyond a reasonable doubt that she was not acting in self-defense. There's no evidence of that. And so that being the case.
But wouldn't it have to be self-defense sufficient to support deadly force?
I'm sorry?
Wouldn't it have to be self-defense sufficient to support the use of deadly force?
And in this case it was. We have a man much bigger who had her pinned and she couldn't get away. Now, I don't know I don't think you can say that because the person is not threatened with a weapon that you cannot resort to deadly force. If you are a woman and you're pinned in a car by a bigger person who has you pinned in arm in arm, so much so that you have to put your arms stretched down to your pockets to try to get a weapon, I don't think that's any different than if the person actually had a weapon themselves and was using it on you. I've had so many cases involving self-defense, and quite frankly, there's a very thin piece of evidence that usually separates this use of deadly force, and I don't quite frankly understand when it's permissible and when it's not. Every circumstance is different. And in this particular case, I have tried to put myself against that car with a woman bigger than me holding me in, and I couldn't get out, and I said, well, I might. I don't know. But it is a situation that's very close to call, and here I'm saying that she's entitled to the benefit of it because the evidence clearly shows that she was not the prime mover here. The evidence shows that this drunk got into her car and wouldn't get out, that this drunk had her pinned against the car and wouldn't let go. And the monkey wrench here, of course, is the testimony of Mr. Michael Collins that it wasn't the defendant at all who did it. So I'm asking you to review the transcript closely. And then, I'm a big boy. You can tell me I'm wrong. But I think you might at least tell me something, and I'll be satisfied. Thank you.
Thank you, Mr. Davis. Good morning, Ms. Lee.
Good morning, Chief Justice. May I please the court? The evidence in this case was sufficient to show beyond a reasonable doubt that the defendant did not act in self-defense. In viewing the evidence in the light...
How many times should we be permitted to put a defendant to trial?
As many times as it needs to. There is, in this particular case, where when you view the evidence in the light most favorable to the Commonwealth showed beyond reasonable doubt that the defendant did not act in reasonable apprehension, that she did not avail to the opportunities to retreat, and that she used excessive force.
Where could she have retreated to?
The testimony of Michael Collins, and in viewing that particular evidence in the light most favorable to the Commonwealth, is that once the victim exited the car, he was standing on the sidewalk of Tremont Street, standing approximately 7 feet away from the victim. He had full view of the victim's right side when he saw 3 to 4 people surround him and start yelling at him. Then he saw the defendant approach the victim, face up to him, and struck him in the neck and the face. And immediately after that, the victim started bleeding. He testified that the victim never touched the defendant, that he was unarmed all evening. He also testified that there were no signs of intoxication exhibited by the victim throughout the entire evening. So if the jury, and in this case,
Collins,
6...
Just remind me, I'm sorry, Ms. Lee, just remind me who Collins was.
Michael Collins was a co-worker at EF International with the victim, and he left the party at approximately 2:30 that evening and waited on the sidewalk while the victim and Danielle Beauregard attempted to hail a cab.
Was there any evidence about how long she was out of the car?
She was out of the car. I believe Mr. Collins testified that as soon as the victim exited the car and went towards the rear of the Cadillac, within a minute, she approached the victim and sliced him in the neck and nearly sliced his ear off.
What was the evidence in the light most favorable to the Commonwealth about the circumstances in which the victim got out of the defendant's car?
The evidence is that Michael Collins said that the victim exited the car. There's no details surrounding how he left the car, whether he was pulled out of the car and by whom. He did testify that he saw the victim exit the car and head towards the rear of the Cadillac. And that's when the defendant ran up to, approached him and sliced him in the neck and the ear. So in viewing that particular evidence, and the evidence that he was unarmed, that he never touched the defendant, and that the defendant had the opportunity after the victim exited the car to jump into a car and leave the area as opposed to following the victim and stabbing him with a knife.
Did he see her at all times, or was his view for a short period of time obstructed by the people who had approached him?
There's no indication from Mr. Collins' testimony that his view was at any time obstructed. In fact, his testimony was that he had full view of the victim's, I believe, right side when the defendant approached him and stabbed him. So based on all this evidence been viewed in light most favorable to the Commonwealth, the single justice in this particular case did not abuse his discretion or did not commit any clear error of law in denying the defendant's petition for extraordinary relief. And the Commonwealth requests that this court affirm Justice Ireland's decision.
Thank you, Ms. Lee. Yes.